Criminal paragraph. This dictation is recorded by Shahid Ramzan, stenographer, Civil Court, Mia Chano, Stenographers Academy, Mia Chano. Ready? Start. The occurrence in question had taken place at about 5 p.m. and the FIR had been promptly lodged within about 45 minutes of the said occurrence, and the instance of Sultan Sikandar PW giving all the necessary details of the occurrence, including mentioning of Alam Khan PW as one of the eyewitnesses, full stop, new para. It is true that the murder of Bahadur Khan, who was a brother of Sardar Khan and Umar Hayat, appellants at the hands of Noor Khan deceased, had taken place about 30 years prior to the present occurrence, but we have it on record that about 5 or 6 months prior to the present case, the parties had exchanged firing and cross cases had been registered at the instance of both the parties under section 307 of the PPC, full stop. And then there was the incident of only a day prior to the present occurrence, in which a murderous assault had been mounted on Noor Khan deceased, and in respect of which also a case under section 307 of the PPC stood registered against the present appellant party, full stop. Needless to mention that the enmity which appears to have started in the year 1947 had not been forgiven and forgotten, and had continued up to the evening preceding the day of the present occurrence, and the latest of the incidents was an attempt on the life of Noor Khan deceased, which had remained unsuccessful till a day earlier, full stop. Thus, a finding that the present appellant's party had a motive to launch the present attack is a finding which is well founded in evidence and is thus, inevitable, full stop, new para. The medical evidence cannot be held as destructive of the ocular testimony only because of some minor improvements which the eyewitnesses had made at the trial, because it would be unfair for a court of law to expect a witness to specifically trace the track of each projectile fired by the assailants, specifically fixing the seat of injury caused by each pellet or bullet fired in the occurrence, full stop. It also has to be kept in mind that in the melee which ensued after the victim party had been surprised by the assailants, such demand from the eyewitnesses would not be just and proper, full stop. In such an occurrence, neither the assailants nor the victims are stationary fixtures. fastened to the earth, full stop. The medical evidence is specifically in accord with the eyewitnesses account and is thus another piece of evidence which corroborates the eyewitnesses, full stop. It had been claimed at the very outset through the FIR that the assailants had attacked the deceased party with firearms and besides having caused firearm injuries to the two deceased persons, had even inflicted blunt weapon injuries with the butt of the gun, full stop.